All right. So I wanted to talk about something today, and I want to thank people who are watching my channel. It seems like the views are growing, and I want to talk about my center today, which is Mason Margiela Jazz Club. And we're going to go and visit something that most people do not understand when they're being sued in a lawsuit, that lawyers can't be 100% conceived as or can be seen as debt collectors. Now, a lot of people, a lot of times when you're sued in court, you receive a notice, a summons, or whatever, or documents by attorneys. And this can be used to deceive you into thinking that an attorney is selecting on behalf of a bank or a financial institution, when the attorney is actually acting on their own volition. Well, attorneys try to act under what is called attorney client privilege. And under attorney client privilege, this affords them certain protections of disclosure. And I'm going to go over a few brief things that you need to know. I'm going to read a publication. It's an older publication from a law firm. So I'm not going to disclose who the law firm is, but I'm going to go through it. But we'll visit what attorney-client privilege is first, so you have a little knowledge of that. All right. So attorney-client privilege refers to the legal privilege that works to keep confidential communications between an attorney and their client private. Now, here's the kicker. When you go into court, they try to use this against you. So you really don't know who's suing you. In my opinion, the person that's suing me is the person who signs all the documents. So if I don't see any documents signed by the person who's allegedly suing me, then generally my perception is that the attorney is suing me. Okay? Communications made by a lawyer in the presence of a third party may not be entitled to the privilege on the grounds they are not confidential. The privilege can be affirmatively raised. Listen, the privilege can be affirmatively raised. Most of you don't do this in the face of a legal demand for communication, such as a discovery request or a demand that a lawyer testify under oath. Now, if a lawyer is signing documents, or if the law firm is signing documents on behalf of their client, you need to bring them people in to question them. I'm not giving you legal advice. I'm just giving you life advice. Okay. A client, but not a lawyer who wishes not to raise the attorney-client privilege as a defense is free to do so, thereby waiving the privilege. Okay, the privilege exists only when there is an attorney-client relationship. So you can ask them to present evidence that they have an attorney-client relationship, in regards to court. And the court will say, no, they don't have to present that. And you'd be like, well, then how are they going to get all their evidence in the court if they don't prove it? I'm giving y'all way too much free advice. And this is, people, this is illegal. I don't really give a damn. Okay, I don't have to use disclosures. I don't give a damn. If somebody sues me, they're gonna lose in court anyway. So look, what you have to understand is under the FDCPA that attorneys are actually debt collectors. So I'm gonna kind of skim through this. There's parts of this that don't have any relevancy, but okay, I'm gonna read from the. I'm just gonna read it all the way through because it's not that long anyway. Okay, from this attorney, it says, my firm's general counsel, infatigable in her mission, opens my eyes on a weekly basis in new and creative ways in which lawyers can be sued, lately in situations where the mistake is not on obvious one who allows you to think. Sure, but that can never happen to me in that regard. Heed the latest warning that hails from the Sixth Circuit and rings the loudest in my ears of real estate practitioners among us. Okay, the Sixth Circuit's January 3rd, 2013 decision in Glazer versus Chase Home Financial LLC and they gave the case number, represents a significant expansion of the confirmation of the reach of the application of the Fair Debt Collection Practices Act. See, I don't sue. If I'm going to sue somebody, I'm not going to use the Fair Debt Collection Practices Act because it limits to what I can do. You see what I'm saying? So I don't like limitations. But you feel free to do whatever you want. That's always you. Okay, the FDIC was enacted some 35 years ago with the objective of protecting customers by eliminating abusive, deceptive, and unfair debt collection practices by debt collectors. And it generally applies to third-party debt collectors. But remember, it isn't generally. But every debt collector is a third-party debt collector, because what happens is even your so-called original creditor is a third-party debt collector. Okay, because they all have trusts, they all have special purpose entities and all of that stuff. So they're all third-party debt collectors. So let's see. Attorneys originally exempt. Wait, where was I at? Okay. Attorneys originally exempt from the purview of the Act became subject to the Act in 1986 if they otherwise satisfy the definition of a debt collector under 15 USC subsection 1692A6 and did not qualify for one of the 6 statutory exemptions. Any person who uses any instrumentality of interstate commerce or mails in any business the principal purpose of which the collection of any debts, or who regularly collects or attempts to collect directly or indirectly. See, indirectly. Now, here's where it drags the attorney into this debt collection. So if an attorney attaches their fees onto a complaint, if they are receiving fees, then the attorney, because the attorney is supposed to be paid out of the sale of the property. They're not supposed to be paid out of the judgment. They're supposed to be paid out of the sale of the property. This is where they get their butts tangled up into this statute. So, like, here's how a foreclosure is really supposed to go, right? When you say you have a foreclosure, okay, the bank has a security interest in your house. Okay, there's no such thing as a foreclosure. It's all a civil forfeiture, okay? But the bank has a vested interest in your house. Okay, when the bank forecloses on your house, what's supposed to happen, this is legally what's supposed to happen. The bank is supposed to take your property and sell it as an REO property. Now, what they get after REO sale, or once the property is on the market, they're supposed to deduct it from the principal balance or the outstanding amount. And from there, they're supposed to send you a statement saying you owe the variance between the principal and interest on the mortgage and what the house sold for. That's what the judgment is supposed to be. But that's not what the bank does. What the bank does is they go to court, they get a replevin on the property, and then they go and they get a judgment of an outstanding amount. That's why I told you have a claim to the judgments in court, but we're not getting there yet. Okay, so look. All right. As a result, there are certain instances in which attorneys can be considered debt collectors and subject to compliance with the Act, which, among other things, may require lawyers to include their correspondence with debtors, specific language, recitations of debtors' rights to obtain further information, and or copies of underlying documents of the debt. So, like, usually when you guys do debt validations, they only send you like bare minimum stuff, like the contract, some statements. That's not what they really supposed to be sending you. But we're not getting there. That even if you ask for more stuff, that's all they'll send. The reason why they do that is because you don't have a contract. Okay, that's what I'm trying to tell you, that almost all debt collectors are third-party debt collectors. That's why you have the Fair Debt Collection Practices Act, because most debts are brokered. They're not done person to person or person to corporation. Even if I go into a building and get a mortgage or a car loan, I'm not doing business with that building. Just like if I go into Verizon and then I go get a cell phone plan, I'm not doing business with Verizon. I'm going into a subsidiary of Verizon and doing the broker deal through them. And then through that deal, Verizon Inc. or whatever the name is, they'll send me a statement because they're the one that's managing the account. So there's no original creditor. They're all third-party debt collectors. Okay, if you understand how things go. Okay, Glazer versus Chase brings the application of the act against attorneys in stark relief. It involved a claim under the FDCPA against a mortgage servicing company. Remember, your company, the company that services your mortgage, is not the owner of it. And this is a big thing. This is a big thing that people need to know. And the law firm it hired to foreclose on the property Glazer inherited. While the Sixth Circuit upheld the district court's dismissal of the FDCPA claims against the servicer, so Glazer filed a complaint under the FDCPA against Chase. Okay, and it was dismissed. Okay, so when we go through that, we're going to tell you why this was reversed. Okay, I don't really get into case law because I don't need it, because I already know. If I know procedure, that's going to trump the case law, because it's going to be, the procedure will bring you back to the Constitution. Okay, because the proof showed the servicer entered on the scene when the debt was still current, which qualified for one of the FDCPA exemptions to the debt collector. Okay, so they're saying if somebody transfers a debt that's current, yeah, because what happened, I ain't even gonna get into this. I'm gonna save this for my private class. I'm gonna show you how, if somebody transfers your mortgage, how to just void out the whole mortgage. I'm gonna show that I'm gonna do that in a private class. Okay, definition. And this comes from I've been in thousands of foreclosure trials, so I already know how to do it. I just don't give out a lot of my information. Okay, it reversed the dismissal against the lawyers. Okay, so they're telling you it reversed it. The claim against the lawyers was that they violated the act by falsely stating that Chase owned the note and mortgage in the foreclosure complaint. Apparently, FNMA, which is Fannie Mae, owned the debt pursuant to an unrecorded assignment. Now, banks will do this. They will record an assignment. And since people don't know how mortgages work, they'll become liable to a mortgage assignment that they should never be liable to. But I'm gonna save that for, because I'm gonna do a mortgage class either this month or before August, and teach people how to get out of their mortgage. It's very easy. So I'm probably gonna do a boot camp. So I'm gonna teach people a lot of stuff. Yeah, going forward, I'm gonna start doing boot camps too. So I'm gonna start teaching law and all that stuff. So help you guys. So if you're interested, I'm gonna start putting more communication on my YouTube videos so people can get in touch with me in other ways besides Instagram. Why not? Why not? I appreciate everybody that's viewing my channel, because you're taking time out to do something you don't have to do. And I'm hoping you're gaining a lot of wealth from it. So, and Chase was solely the servicer. Okay, there's a difference between the servicer and the owner. Please know it. Okay, that's why I gave you the Verizon thing. The contract, whenever you go into a building, it is usually the franchisee of a corporate office from somewhere. Okay, and you can find this out by looking up SEC website. Go to the SEC website and you'll find all this out. Okay, and properly scheduling a foreclosure sale, which was ultimately canceled, and refusing to verify the debt upon the debtor's request. Okay, so in upholding the claims against the lawyers, the Sixth Circuit cited that the act was unclear because it failed to define debt collector and did not exclude foreclosures or the general enforcement of security from its scope. And the court rejected that what it characterized as a majority view adopted in many district courts, that mortgage foreclosures without a claim for a money judgment. Listen what I'm saying, without a claim for a money judgment. So if they do a claim for a money judgment, the lawyer is a debt collector. They're not. That's why I'm trying to tell you, they're not supposed to in a foreclosure, because there's no such thing as a foreclosure. It is a civil asset forfeiture case. They cannot do a money judgment. The attorneys cannot do a money judgment, especially under a federally funded loans. They can't receive kickbacks. So that means they would have to strike out the interest. They would have to strike out certain things or the elements of the judgment that can actually get the case thrown out. Okay. And a foreclosure complaint is not a debt collection, but simply enforcement of a security interest. Let me go back. Okay. Without a claim for a money judgment. So if they claim for a money judgment, the attorney is a debt collector. That's what it's saying right here. Very clear. I'm going to reread it for you so you understand this, people who are going through foreclosure, so you can stop bringing up stupid arguments like securitization and all this other dumb stuff that people have you bring it up, because they don't even know how to make you bring up securitization properly. I'm bringing that in my foreclosure case. I'm bringing that in my foreclosure boot camp. I'm gonna show y'all how to start getting out of this stuff, because I hold a lot of information I could just be released to the public, but sometimes you got to. Okay, without a claim for a money judgment in a foreclosure complaint, is a foreclosure complaint is not a debt collection. So if there's no requested money, because technically, just like I said, when a foreclosure takes place, the bank is supposed to secure. They're supposed to secure their interest and foreclose out the interest, but they can't do that because to go through court, you must have what? A controversy. Okay. Y'all learn a lot. Y'all gonna learn a lot of stuff if you actually apply this and study what I'm saying. And you can use a lot of Google when you're watching my videos. You will learn a lot. Okay, despite the absence of a definition of debt collector in the act, the panel examined the act's definition of a debt, which is defined as any obligation or alleged. See, any obligation or alleged. You guys, I'm going to do another video and I'm going to tell you how you're getting into debt, how you can get out of debt, and how you can take that debt and turn it around and become the creditor. Okay. But as of now, you have to understand what an allegation is. An allegation is a presumption in law. So, and presumption in law will be enforced by a court of competent jurisdiction because there's nothing to rebut the presumption. Okay. Of a consumer to pay money arising out of a transaction in which the money, property insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes. 15 USC subsection 1692A5. Further, the court focused upon the Act's substantive provisions that debt collection is performed through either communication or conduct. Okay. So if somebody sends you a letter, if somebody sends you a call, if it's an attorney and they're trying to receive money, they are a debt collector. It's just saying it right here. If somebody's attorneys try to get out of this, oh, I'm not a debt collector. Yes, you are. Because when we used to have trials, what they would do is they would transfer the file to the attorneys. And I'm not going to get into this. I'm going to keep this in a private. I'm going to show you. The attorney is 100% collecting that debt. What they're doing is they're using the bank's name to, get it, as a agent, a vested agent. But I'm not getting into that now, which it found to be an indication of a very broad view of what could be considered collection under the statute. As to the agreement that enforcement of the security interest should be distinguished, the panel stated the focus on the underlying transaction indicates that whether an obligation is a debt depends not on whether the obligation is secured, but rather listen to what they're saying. See, all these people telling you file a UCC1 and blah 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 blah. They don't even understand. They don't even understand what they're doing. Okay, man, it's the blind leading the blind out here. It'd be so crazy that I struggle to get 100 views, and people will get 1,000 views giving you the wrong information. It's crazy. Okay, but rather on the purpose of which it incurred. Okay, so now they're telling you how to get out of your debts. If you listen to what they're saying, I'm going to read it to you again. So this will tell you to stop bringing up these dumb arguments that people are bringing up in court. They're telling you how to get out of your debt. Okay, The focus on an underlying transaction indicates whether an obligation is a debt. Okay? So now you have to go in. What is the legal definition of a debt? Do I owe it? What was given to me? What does the bank have any proof that they have a deficit on their books? I'm just giving you great information. Depends on not whether the obligation is secured. So people, a UCC was secured, but no, it doesn't. The underlying debt you always have to deal with what got you there. Okay. So let me go back and read again. I apologize. The focus on the underlying transaction indicates whether an obligation is a debt. Depends not on whether the obligation is secured, but rather on the purpose of which it incurred, concluding that a home loan was a debt, whether or not secured. See, because most people do not understand mortgages are not secured. They're not secured. They're not secured. Just like your car loans, they are not secure transactions. They're non-recourse loans. So I was going to release that later, but I'm gonna get into it. I'm gonna show proof. I'm gonna show case law. I'm gonna show proof of this later. So ultimately, the Sixth Circuit's holding was that the very purpose of any mortgage foreclosure is to obtain payment on the underlying debt. That's what makes the attorney a debt collector. So if what they're supposed to do under Fannie Mae and Freddie Mac loans or Ginnie Mae loans, they're supposed to the attorney's fees are supposed to be wiped out, and some of the other fees, the interest and all the stuff, is supposed to be wiped out. But you got to read TILA, you got to read TILA to understand that. But yeah, they can't. They're not allowed to get any kickbacks on federally funded loans. So if they foreclose out and they have attorney's fees and all that stuff, oh my goodness, they are creating more problems for themselves. Either by persuasion, a settlement payment, or compulsion. A foreclosure judgment, there's no such thing as a foreclosure. It's a civil asset forfeiture, but that's not here or there. A foreclosure judgment and application of the sales proceeds against the debt. That's what they're saying. They're saying a foreclosure judgment and application of sales proceeds against the debt. So if they have the amount of the property and they have the amount is sold, they're supposed to deduct it, and that's what you're supposed to owe. You see what I'm saying? Because they can't sell property without just due compensation, meaning they have to give you your money back because the contract is annulled now, or the contract is no longer valid. But we're not getting there. And thus, a lawyer who regularly tries to obtain payment of consumer debts through legal proceedings is a lawyer who regularly attempts to collect debts per the act. Stated otherwise, if the purpose of an activity taken in relation to a debt is to obtain payment of the debt, then the activity is properly considered debt collection under the FDCPA. Woo-wee! This is lawyers telling on other lawyers, because what these lawyers are doing is fraud. So that means if a lawyer is doing debt collection, trying to get money from you, that's debt collection. This holding, which is echoed in several recent opinions from the Third and Fourth Circuits, placed real estate attorneys squarely in the path of the FDCPA. This ain't no different for real estate collectors. This is from the attorneys who repo cars, all that stuff. And while there could still be arguments for exemption, if, for an instance, the attorney does not regularly seek to collect debts, it strikes that this lawyer that a conservative approach is sounder approach for those of us engaged in any foreclosure activities on behalf of our clients. Ensuring compliance with the act will require examination of the form and substance of all oral and written correspondence with the consumer debtors, including emails, to consider whether or not to append disclaimers or statutory requirements, language and due diligence. In diligence in respect of the counsel's conduct throughout the foreclosure proceedings, and no doubt will generate more food for thought for my general counsel. Now, what this attorney is telling you is like, oh God, we're debt collectors. You see what I'm saying? So we're subject to FDCPA, so we can't use the same deceptive tactics that we've been using. So we have to get slicker. So if an attorney or an attorney's firm is signing a complaint on behalf of their client, they are not. It's not. Then what they're doing is they're committing fraud, because when you're filing a complaint, the complaint is supposed to be verified by the party that is alleging the complaint. So they're supposed to sign off on it, and then the firm is supposed to sign off on it, because what they're doing is really transferring their interest to the firm and letting them collect on behalf. But they can't do that anyway. And you know why they can't do that? Let's go back here where it says that the loan has to be what? Current for them to transfer it. So all foreclosures are illegal. Holla at your boy. We out here in Winter Circle. We're getting our wins. I'm out.